Classified crime is on the case of Sarah Boone, and today we're going to get into her family court documents starting with 2023. Let's get into it. Okay, so we're going to get started with this letter from Sarah written on January 23rd of 2023 and filed on 1/31. And it also says it was received by the public defender January 26th. So that to me means that the family court sent this over to the public defender's office. At this time, her attorney, I went back and looked, it would have been Bankowitz. So I'm not really sure why that stamp is there or what was the reason they sent it, but apparently they did. Honorable Judge Dean, hello and Happy New Year. I hope the holidays were kind to your family and many wonderful memories made. I too would like to have a Happy New Year, as this will be my third in Orange County Corrections, not by choice. Well, no one stays in there by choice. Like, you're all forced to be there. That's the whole purpose behind the cuffs and the bars and the cell and the security guards, and all of that is because nobody would just remain in there by choice. But you did have a choice in your actions that got you there. So that's the part you need to start focusing on. 2023 is going to be my year of simplification. I am going to simplify anything and everything I can to avoid any added stress and confusion on top of the already. This is my year of significance also. I am significant. I am not going to be demoralized and made to feel like a comedic lame doormat by anyone any longer, especially by former husband. I choose happiness no matter what, and am going to be the best that I can to my son, most of all, where I am, which is not forever. Please remember this and know that I am doing everything I can to have a successful year. The judge, it makes no difference to the judge whether either party has a successful year. That's what being impartial means. And when you say this is not forever, I seem to remember you stating otherwise. Please hold.
When I leave, this is forever. When you all leave, that this is forever. This is forever for everyone here and those who it matters to most. I am one of those who will experience this forever.
The purpose of my letter, Your Honor, is to please request a hearing to simplify and clarify some of my ongoing legitimate concerns with former husband, so I am able to somewhat enjoy my year for however long it may be. Well, it'll be 365 days, unless it's a leap year. I still have no attorney for this matter, but believe with your authority and overseeing, I can be rightfully heard and understood as I was able in our last hearing back in September 19th, 2022, for the same reasons. I am contacting you again. I can only imagine how hectic your schedule is, and I know your time is invaluable, which is why I'm hoping everything needing to be addressed can be done quickly and only once, because of the extended amount of time that I've been quietly dealing with former husband and his nonchalant, cruel attitude regarding my concerns. Also, the growing mountain of lies and laughter. People aren't allowed to laugh now? I feel my requested hearing is overdue and most definitely needed. Simplify. I kept praying things would change. Sadly, they have not. To summarize, here are my concerns, please. I would like to address. She inserts this word in the oddest places to me. 1, as his mother, my role in my son's life. I matter. I have rules, health concerns, appointments. You cannot make or bring anyone to an appointment. School, grades, church, friends, behavior, eating habits, computer time with a star. And she wrote, please discuss specifically. Okay. Sports, group activities, and more I want to talk about should be included on and have a right to be. Your rights have changed now that you are the property of the state of Florida. Most of the time, if I don't initiate, inquire about, or stay on top of, nothing happens or is cared about other than by me. And I'm incarcerated, which makes no difference. I am still mom with mom rights and concerns. I make a difference in my son's life and forever will. That is true. You make a difference, whether it's positive or negative. That we do not agree on. I will never stop caring, and he knows that. So, how are you exactly supposed to be staying on top of anything? You're definitely not staying on top of your case. It does make a difference that you're incarcerated. It makes a huge difference because you can't do anything. So, asking the other person what they're doing, it's of no significance because you're not going to participate in any of that. You're not going to take him to a doctor's appointment. You're not going to drop him off or pick him up at school. You're not going to attend church. You aren't going to buy any groceries. None of this stuff is relevant for you. 2, former husband and his family to stop talking about me as mother and about my case to son. Well, I'm sure he has questions. Every time he asks a question about where's mom, what's going on with mom, what happened to mom, they can't just like run to the other room and pretend it's not happening. Kids have questions and they have to be answered, and you just don't like him being told the truth. I know everything, my son rudely and sometimes laughing tells me about my divorce, my crazy deceased family, my brothers, why I am incarcerated and am yelled at sometimes from what only God knows former husband has said or what you did. Please note, 2 weeks into my incarceration, he decided to self-diagnose my situation, egregiously telling our at the time 9-year-old that he wasn't going to see me, his mother, for 25 years or more of his life, if ever again. This extremely selfish, idiotic decision has forever made my son keep his distance, and he is scared to be 100% with me for fear if he gets too close truly and deeply that I'm going to put him in that I'm going to be absent and out of his life. So what's point? She's assuming some obscure thing someone said has made him keep his distance, but it might just be the fact that he's horrified at what happened. And the fact that his mother would be capable of that. I would certainly distance myself from a family member who did something like that. There's so many other detrimental comments former husband has made, and it's poisoning our son and pitting him against me. Former husband does not think before he speaks. To simplify, and you don't think before you leave someone in a suitcase and go upstairs and go to sleep. So, which is worse? To simplify this request, please, Your Honor, instruct him and his family to cease and desist any further comments, opinions, assumptions, accusations, diagnosis, anything negative discussed with my son. Stop talking about me. Okay, but a few sentences ago, you matter, you are significant, you're still mom, but they're not allowed to talk about you. Probably has a lot of questions that are tough for them to answer and tough for him to process, but you're not in any way concerned about that, about how he is dealing with this. You think that he doesn't wonder why you're in jail? He has questions, they're answering them the best that they can. This is not in any kind of parenting book they can read about, oh, what happens if mom, takes someone's life and ends up in jail. This is not like some big common parenting topic that they can get expert advice on easily. What an idiot. 3, private phone time with my son. Former husband is constantly in the background interjecting his comments, answers questions. I'm asking my son, laughing and telling me through my son what I can and cannot say to him, e.g., asking about friends, school dances, sports, etc. Also, former husband is always seen and heard during my 15-minute video visit, impeding my valuable time with my son. I call him not former husband foremost. My son is a completely different person when not around his father. I am lovingly spoken to most of the time and told about everything under the sun. So much is said when just me and him. There is also no pressure to be mean to me like dad is. Private phone time will be my time and made to be important and meaningful. I like how she's dictating this to the judge. This will be what you order them to do, and it will be this. Where do you get off deciding that for everyone involved? It will also get him off the computer, which has been a huge topic of attempted discussion with former husband with no success. Wherever my son wants to sit, inside or out, and whatever he wants to talk to me about should be allowed freely and without difficulty, unless he has questions about the things you did, in which case he's not allowed to talk about them. And also, your former husband is a computer programmer, so I don't think he's going to have a problem with your son being on computers and learning about them and doing things on them. Maybe he wants to do what his dad does. Did you ever think of that? This includes phone and video visits. 4, moving misconceptions and assumptions. We all know how this turned out. I am told on a daily basis about all the hustle and bustle, repairs, contractors, etc. for the house to be sold as soon as possible so former husband can take my son and move away from me. Actually, they're going to be moving closer to where you're going to end up. So, another reason I am withheld monetary funds to make my necessary purchases. When trying to rationally discuss the topic of moving, I am either yelled or laughed at or just told that it's happening. I want to make sure former husband abides by the 50-mile radius and all other moving rules included. He assumes he and my son are going to ride off into the sunset and leave me in the dust, knowing I have no attorney, money, or family, which he seldom reminds me of, telling me there's nothing I can do. Leave you in the dust? It's not their fault you don't have an attorney, money, or family. Are you saying he often reminds you? Because seldom remind you is not mean. I don't want to hear him talking about it all the time anymore and get it right when you do. Please, Judge Dean, clarify so he knows for definite what to plan on and can make the necessary changes, including saving money in order to bring my currently negative jail account in the positive to make my necessary purchases. So all of this is just his responsibility. She doesn't want him to make the house ready for sale. She wants him to save money to put in her account so she can buy commissary instead of selling the house, taking the equity, and starting over for him and their son. That is so selfish. I am requesting also to be kept informed with any updates regarding moving plans, especially since it includes taking my minor son. 5, stop assuming my case details and quote-unquote progress. Former husband assumes I actively am making the decision to postpone my trial, yes, like we all did, and keep them here, that I actively am making the decision to possibly be on my 7th attorney from all the withdrawals. You mean withdrawal? Not firings. Okay, so just because they ran for the hills and quit doesn't make it better than if you fired them. That actively I am enjoying my 3rd year in jail away from my son and our life together, away from everything, and want to stay in this morbid, daily, vicious cycle of depression. Stop telling me what to do, how to do it, and when, from listening to all his reliable sources, such as professional YouTubers, that's me, court TV, social media, etc. I am constantly told he knows what's going on and how it's going to end. He believes, along with so many others, all the hype and hate generated towards me from all the ignorant misunderstandings No, we watched a video. We know exactly what happened. Coming from everywhere. I don't even know what's going on after the nonstop debacles and insanity I've been going through, dealing with and trying to sort out all the lies for 3 years and counting. Why don't I fire my attorney and hire former husband? You don't know what's going on, but you don't want him to know what's going on because then you don't know and he does. You're saying stop telling me what to do and how to do it, but you're asking the judge to tell your former husband what to do and how to do it. So, what's good for the goose and all? 6, alimony monetary income agreement. Since our last hearing, former husband was ordered to continue paying alimony. This is why I think she is like, she doesn't hear or compute or comprehend what everyone else hears. It's like the order said that they weren't going to rule on it. Now, I don't know what the judge said out of his mouth in the hearing, obviously, but the order he wrote and put in the record said that he would wait until the criminal trial was decided before ruling. That is what the order said. We looked at it. So she's under the impression that he was ordered to continue paying so that she can purchase books, food, clothing, hygiene items, etc. Often I am denied and go without what I am needing. That's subjective. I am still waiting for everything, including pictures my son wants me to have, and a check from my grandmother's deceased interest, $100 he keeps telling me has been mailed. The check is almost a year old from waiting so long, 2/2/22. I don't even know if it's even able to be used at this point. I keep waiting and waiting for this check, especially so I can put in my negative account and not ask former husband. It was my understanding I could have the aforementioned after the hearing concluded. I have not and am repeatedly told he's waiting to get a job, moving expenses are more than expected, still waiting on a big check from his parents to clear his account, or there's some kind of glitch. There's always a problem, reason, excuse. He even openly admitted to me I guess this was lies and has, so I never know when and if the truth is being told ever. He tells me every time it's been ordered, mailed, coming soon, or on the way. Where is it? Any of it? The lying was a great factor in our divorce also. I even took the effort to communicate that I feel like a dumb dog looking out the window, wagging my dumb tail, waiting for everything good after he's told me there will be, and to keep looking. Nothing ever. My solution, please, is to establish a payment plan with due dates to simplify this ongoing problem going forward. I choose not to be lied to any longer. That's not your choice. If people lie to you, they lie to you. It's not your decision any longer than I already have, and to keep looking out the window for nothing. It's humiliating. This is a true statement. You are humiliating. 7, communication agreement. Everything regarding my son, including health concerns, behavior, discipline, appointment results and details, grades, report cards, school reports, emails, notifications, planned trips and vacations, not days before, all general and important discussions as they arise. How does it affect you if they go on vacation? You're not going to go. You can't get online and see pictures they take. You can't call them wherever they may go. There's literally nothing you can do about what they're doing on the outside. They didn't commit crimes and they're allowed to go on vacation, whether you approve of it or not. They're allowed to spend money, whether you think they got it from a legitimate source or owe it to you or not. They're allowed to enjoy their life. All general and important discussions as they arise. Lack of communication, another massive reason for our divorce. Not communicating overall, such as when our home was being foreclosed on twice during our marriage, or that my 30-year-old bank account closed from excessive delinquency due to not receiving alimony. That's not the only reason. Another reason for not receiving necessities from autopay being disabled from no account and former husband's debit credit card never works. Mine would, and for every purchase prior to closure did, but is now obsolete and unusable. Yet your card worked because your husband was putting funds in it. So that was the only reason it worked. If he's not putting funds in it, your card wouldn't work either. Communicate, update, mention, educate, make aware, notify, however, whenever, whatever, just please communicate. Release documents for mortgage. I was served a summons on 9/27/22 regarding a lawsuit against me for non-payment and foreclosure of now since 2017 former husband's house, which I signed documents in our dissolution of marriage relinquishing my shares. So you did know that you are not owed anything from the house. Relinquishing my shares, interests, and ownership. So right here in your own handwriting, you do understand that if he sold the house, you're not owed anything. I am still included on the mortgage and my name on all the paperwork in the summons. I have repeatedly requested former husband to please contact the mortgage company to inform them I am not affiliated in any way and to remove me completely and finally. I was told previously by him it makes no difference. The house is practically sold or it's been taken care of. Which is it? I would like to receive a formal letter stating I am removed from the mortgage company. I do not need anything extra on my credit score that hasn't negatively already been done from everything during and after our marriage that was unfairly dumped on me by former husband. Please provide copies as soon as possible. You mean that 44 grand of credit card debt? 9. Permanent documents. Information from hearing 9/19/22. Please provide the permanent documents, full custody and suspension of child support. Former husband's attorney was instructed to forward for your modifications, Your Honor, to temporary as requested. After I was able to explain my circumstances with having no money or family to hire an attorney once I am released in your dreams, and my desperate need to be fully and completely reunited with my son ASAP, you graciously made the decision to make everything temporary. Thank you. Were these ever sent and completed? I haven't received copies. If so, which I very much would like and need, please, along with any other paperwork generated since the hearing so I can be kept updated with anything new I may need to work on. I completed a change of address form during the hearing also to make sure correct and everyone was aware so I can be able to receive copies, letters, etc. going forward. 10. Copy of dissolution of marriage, divorce paperwork. I keep trying to receive a copy from former husband for my personal reference and information to utilize during our ongoing and current case together, but I have not yet received. Why would he provide you with that? A, you're on opposing sides of the case. So why would he do something that benefits you in the case that he is against you in? Second, it's not his responsibility to provide you with copies. You had your own copies, but then you became in the custody of the Orange County Corrections Department, and you're not allowed to just go grab the copies you have. So you have to obtain your own, no matter how impossible a task it is. I would like a copy for future review if needed, if the court is able to provide. You have to pay for copies. You have to formally request them and pay for them. They're not just going to send them to you. I would be grateful and can possibly receive much sooner. Please know, Your Honor, I am always coming to former husband with solutions for everything to make all that I can easier, less painful, and more productive. That is the biggest lie. I ask days, sometimes weeks in advance for a reason to simplify our lives now and future. I do not ask for anything difficult or unreasonable regarding my son or books or toothpaste. You put your son on the same line with books and toothpaste. I just keep taking the abuse, then have to say thank you in hopes something might really finally happen. It does not. I'm trying to avoid predictable one-sided arguments, even more snide, backhanded, unnecessary comments, and supposed this is how it's going to be statements. And a narcissist does not like you to tell them that this is happening or this is how it's going to be. That really enrages them. The latter, I'm hoping, comes from you, Judge Dean, in one way or another. We all need to be on the same page and level with the same understanding, rules, and agreement. Please help clarify and justify my concerns to keep the peace so everyone can plan accordingly, abide correctly, and work together. I await your response and hopeful hearing date information. Always trying and beyond grateful, Sarah Boone. You want everyone to be on the same page, your page. If it's not what you want, it's a problem. And you said that in the last letter that you were not willing to do anything on your ex-husband's terms. You already told the judge this, which is why they dispensed with the mediation. So another unhinged letter from Sarah to the judge. Okay, so starting off 2023, we looked at Sarah's letter. Now we're going to look at this petition to relocate that Brian files with his counsel. They issue a summons to Sarah to appear in court, and they have an order setting the hearing for 4/13/23. And then we have a letter from Sarah and a motion for a status hearing written the same day that this order for the hearing was placed. But let's take a look at those things. This was filed February 14th, 2023 by Brian's attorney. Petitioner's verified petition to relocate comes now. The petitioner, Brian C. Boone, by and through his undersigned attorney, who hereby files this verified petition to relocate, and in support thereof states as follows. 1, this is a post-judgment action for relocation. 2, there is one minor child subject to these proceedings, to wit, date of birth 2010. 3, the petitioner requests to relocate to a city in Florida with the minor child, and said relocation is in the best interest of the minor child for the following reasons. A, since February 2022, the respondent has been incarcerated and is awaiting trial for second degree M. The allegations include her locking her boyfriend in a suitcase until he passed away. The case has gone viral over the last couple of years on social media and is causing the minor child significant difficulties at school. Notice how this is straight to the point about how these events affect the child and what would be in the best interest of the child. B, the minor child is being bullied at school consistently for his affiliation with the case and is seeking counseling for the bullying. The minor child would benefit from moving outside of the jurisdiction of his mother's case and around children that are not familiar with his link to the case. Very valid point. C, the petitioner has immediate family in the city he's trying to relocate in Florida that can provide support to the minor child as he processes this situation. So extended family, support for a single parent. D, the respondent has had 0 overnights with the minor child for the last 3 years and is not involved in the child's day-to-day activities due to her incarceration. If the respondent is found guilty, she will be incarcerated for the remaining minority of the minor child. If the petitioner moves, it will have no impact on the respondent's current time sharing and contact, because phone calls, it doesn't matter if you're still within the state, it's not long distance, and it doesn't matter where you are to make phone calls or electronic messages or video chats. E, with that said, the petitioner will work diligently to preserve the child's relationship with the respondent if said relocation is granted, which means he will fund electronic messages and phone calls and schedule video visits, none of which would affect her communication with the child. F, said relocation will greatly enhance the general quality of life for the minor child and the petitioner financially. Further, the minor child will have access to far greater opportunities, educational opportunities. G, said relocation will dramatically improve the economic circumstances of the petitioner and the minor child. H, petitioner is seeking said relocation in good faith. 4, the exact address in this city is unknown at this time and is subject to the relocation being granted. 5, the telephone number for the petitioner will not change. 6, the petitioner requests the relocation to be effective immediately and requests a temporary relocation hearing to be set as soon as possible, pursuant to Florida statute, given the situation of the minor child. 7, the petitioner does not wish to deprive the minor child of his relationship with the respondent and would therefore propose a long-distance parenting plan as follows. And there's a footnote here. Predicated on the respondent being released from prison and being found fit to have overnight time sharing. This is the proposed plan. So, if the respondent is released only. And also, I'd like to point out this is just about an hour away from where they were currently living at the time. So, if you're not willing to drive half an hour to meet halfway, or, drive an hour to drop off and the other person drive an hour to pick up, that's really not a huge inconvenience to drive 1 hour. Some people drive an hour every day to work. A, every other weekend from Friday evening until Sunday evening between the respondent and the minor child. So every other weekend. B, the petitioner and respondent would alternate winter break and Thanksgiving time sharing annually. C, the respondent would exercise time sharing with the minor child every other spring break. D, the petitioner will provide the necessary technology for the minor child to be able to Skype/FaceTime or alternate video conferencing of the minor child with the respondent on a regular basis, a schedule of which can be solidified upon determination of the formal long-distance parenting plan. E, the parties would be responsible for their own transportation costs. And this is all in all caps from here. And I don't know if it's just so Sarah will pay close attention to it and not say she didn't see it, but this whole paragraph is in all caps and bold. A response to the petition objecting to relocation must be made in writing, filed with the court, and served on the parent or other person seeking to relocate within 20 days after service of this petition to relocate. So we're going to get an unhinged response from Sarah. If you fail to timely object to the relocation will be allowed unless it is not in the best interest of the child or children, without further notice and without a hearing. Now, that alone is going to upset her because that she doesn't like dates, deadlines, timeframes, and parameters put on any of her rights. No restrictions should ever be placed on her in any way. 8, if the respondent files an objection to this petition to relocate, it should be served on the petitioner, care of the Martell Family Law Firm in Orlando, Florida. 9, the petitioner has employed the Martell Family Law Firm to represent him in this matter and has agreed to pay the firm reasonable attorney's fees and costs for this representation. Wherefore, petitioner Brian C. Boone respectfully requests that this court enter an order, A, granting this position for relocation, permitting the petitioner to relocate. B, granting said relocation on a temporary basis and setting an expedited hearing on said temporary request. C, granting this petition for relocation and ordering a long-distance parenting plan in the best interest of the minor child of the parties. D, granting petitioner an award of attorney's fees incurred in pursuit of this matter. E, granting any other relief the court deems just and proper. And then it just says they understand they're swearing under oath. Brian has signed it and it is notarized. And there's a certificate of service. It says, I certify that a true and correct copy of the foregoing petitioner's verified petition to relocate has been delivered via service of process to Sarah Boone on the date and time as detailed in the acceptance and affidavit of service to be filed herein. So they sent a process server. So let's take a look at that. All right, this is the summons, and it was filed February 16th. Summons, personal service on an individual for Sarah K. Boone, respondent. A lawsuit has been filed against you. You have 20 calendar days after the summons is served on you to file a written response to the attached petition with the clerk of this circuit court located at the Orange County Courthouse. A phone call will not protect you. Your written response, including the case number given above and the names of the parties, must be filed if you want the court to hear your side of the case. If you do not file your response on time, you may lose the case, and your wages, money, and property may be taken thereafter without further warning from the court. There are other legal requirements. You may want to call an attorney right away. If you do not know an attorney, you may call an attorney referral service or legal aid office listed in the phone book. If you choose to file a written response yourself at the same time you file your written response to the court, you must also mail or take a copy of your written response to the attorney for petitioner named below. Copies of all court documents in this case, including orders, are available at the clerk of court's office. You may review these documents upon request. You must keep the clerk of court's circuit court's office notified of your current address. You may file notice of current address, Florida Supreme Court approved family law form. Future papers in this lawsuit will be mailed to the address on record at the clerk's office. And then it just has a generic warning, and it lists this in Spanish and French as well. And then it has the attorney listed and the sheriff's service of the summons that they're ordering the sheriff to serve it. And this is the judge's order setting the hearing. He filed it at 2/21/23. It says order setting hearing. This matter came on before the court, and the court, after reviewing the file and being otherwise informed in the premises, it is hereby ordered and adjudged as follows. This case is scheduled for a hearing on status hearing filed 2/14/23 on April 13th, 2023 at 1:30 p.m. in courtroom 16G, Orange County Courthouse, time reserved 30 minutes. It says to bring your own interpreter if you should need one. And this was ordered the 21st day of February by Judge Michael Dean. And then it talks about certificate of service. A true and correct copy was delivered to Sarah Boone and the attorney. So she received, this was mailed to her, according to the court document. And then we have this filed from Sarah. It was written February 14th and filed on February 22nd, 2023. I don't believe that she had received the summons yet at this point because the judge had just filed it and probably mailed it. So it hadn't reached her by the 14th when she wrote this. Honorable Judge Dean, hello again. It is my understanding the letter I wrote to you on 1/23/23 has been received by the court and uploaded to the clerk's website on 1/31/23. I have not gotten any type of response, even a copy of my letter as usual, so I'm not sure what happens now or the protocol for scheduling a status hearing to address my overdue concerns from the aforementioned letter. I have no representation for this matter, so I've included a motion for a status hearing on my behalf, please, to hopefully initiate and expedite the process to schedule, which they've already scheduled a hearing, but it's on the motion to relocate. I am unsure what else I need to do that I haven't already or am trying to do. I hope the second letter and motion conveys my sincere care and need to finally clarify and hopefully conclude some of these ongoing growing misunderstandings by former husbands so I too can receive quote unquote relief, however I am able to acquire for myself by myself since he is unwilling to properly cooperate. The shade she throws in here about he's unwilling to cooperate, it's just completely unnecessary in a legal document. Did you see? I mean, she's getting copies of all of the professionally written motions from Brian's attorney. Just take that format, change whatever you need to change Use the exact same format and file it. Stop throwing shade. It makes you look bad. It doesn't make Brian look bad. It makes him look like the rational person, which, I mean, is obviously true, but she always wants to throw something like this in there. And you don't need to. You just need to say, I object to this. I'm filing the motion for a hearing. Here's the dates, whatever. That's it. That's all you need to say. Also, the very extended amount of time for him to do so and has not, only compiling more concerns on top of the already. I am even more desperate to avoid and alleviate what I can, however, and as soon as I can for everyone, Judge Dean, please see and understand my emphasized attempt and graciously grant the motion. Huge run-on sentence. Thank you always for your welcomed and extremely appreciated information, assistance, and patience. I await your response and instruction. Again, thank you sincerely, Sarah Boone. And here's her motion. Motion to set status case management hearing. Comes now, Sarah K. Boone, respondent, submits her request to the court for a motion to set status case management hearing to be scheduled at the court's earliest opportunity and convenience for further discussion of submitted concerns by respondent on 1/23/23. That was really not any kind of formal petition, but it was just a letter. But she wants to address those concerns. The last case management conference was held on 9/19/2022. So just over 4 months ago. And since agreements ordered by Judge to Brian C. Boone, petitioner, have not been upheld or abided by, also due to the continuation of concerns therein and the growing additions to prior, that makes no sense. Respondent requests expeditiously for said hearing to be scheduled to conclude and avoid any further confusion. You cannot avoid confusion when Sarah's involved. Or difficulty going forward and provide relief to all parties, including the court. Now, how are you going to provide relief to the court? How does the court get relief? I mean, you still haven't paid that fee from part 1 video that we looked at. That's probably the only relief they're seeking from you. Wherefore, Sarah K. Boone, respondent, respectfully requests that this honorable court please grant this motion and enter its order to set a status case management hearing regarding the aforementioned information. Thank you, Sarah K. Boone, Orlando, Florida. And she has the envelope with legal mail written on it. Okay, and then we have this answer to the summons for the petition to relocate. So she wrote this February 21st, and it was filed March 1st of 2023. Dear Clerk, I received this summons today and am responding within the 20 days as stated therein. I object to the petition to relocate. Of course she does. Please set a status case management hearing as I previously requested in my letter to the Judge Dean stating my concerns prior to receiving this summons on 1/23/23. Upload it to the website 1/31/23. I also sent a follow-up letter and motion for the same on 2/13/23, but have received no response and has not been added to website to date. I am sending handwritten copies to the clerk of courts, Judge Dean, and petitioner's attorney who can serve to former husband his client as I have no way to do so while incarcerated. My main focus goal at this time is to send my response and objection to the petition to relocate to the clerk as soon as possible, as instructed in the summons. Well, good. Thank you for following directions. Please send copies of scheduled hearing with the date and time so I am aware and can prepare. I have no representation in this case and can only be kept updated by these copies. I await the court's response and information. Thank you, Sarah Boone. Please update my address. Now they can only update your address if you fill out the change of address form with the court. They already did send her out the notice of hearing on the same date. She just obviously hasn't received it yet through the mail. So she is going to, and they've already said it. This is her duplicate handwritten copy. She wrote this on the 21st, and this one was filed on the 23rd, whereas the second copy was filed on 3/1/23. But she did say she was handwriting a copy to file. So that's what I think this is. It says, I am sending handwritten copies to the clerk of court, the judge, and petitioner's attorney. So I think she just sent two, and they arrived on different days and got filed different days. Then we have this order directing Orange County Corrections to transport the defendant. It was filed 2/28/23. Orange County Corrections are hereby ordered to transport defendant Sarah K. Boone by any means necessary from Orange County Jail to Orange County Courthouse on Thursday, April 13th, 2023, for the purpose of status hearing set to take place at 1:30 p.m. in courtroom 16G, signed by Michael Dean, and it has a certificate of service that they e-filed it and they sent it to electronically to the Orange County Corrections. This is the motion for temporary relocation, filed 3/6. It's very similar to the petition Brian filed for relocation with his attorney. It's just a little shorter. It doesn't have as many sections. So I'm just going to briefly go over this because we already kind of looked at the petition. But it just basically says he's filing a motion for the temporary relocation and lists that this is a post-judgment action for relocation. There's one minor child. He wants to temporarily relocate to a city in Florida, pending final order for the following reasons. Since February 2022, that should say 2020. The respondent has been incarcerated and is awaiting trial for second degree. Allegations include, and it lists what she did, that it's gone viral, and that it's causing the child significant difficulties at school. The minor child is being bullied at school consistently, and they want to move out of the jurisdiction of the mother's case and around children who are not familiar with him being linked to the case. At this time, the respondent's trial was scheduled for April, which is a month from when this was filed. And the petitioner has family in that city that can help him raise the child. It reiterates that the respondent has had 0 overnights for the last 3 years, is not involved to day-to-day activities due to her incarceration. If the respondent is found guilty, she will be incarcerated for the remaining minority of the minor child. If the petitioner moves on a temporary basis, it will have no impact on the respondent's current timeshare and contact because it's over the phone only at this time. She was in the Orange County Jail and there were no in-person visits. The petitioner requests the relocation be effective immediately and a temporary relocation hearing be set as soon as possible, given the situation of the minor child. So he's always focusing on this is affecting the child. This is why I'm filing this. And then he has a lawyer representing him. He asked the court grant the motion, set an expedited hearing, and any other relief. So he has an attorney to represent him. He's requesting they grant the motion, set an expedited hearing, and any other relief, and then they certify that a copy was sent to Sarah at the Orange County Jail. All right, so we looked at our letter from Sarah and her motion for the status hearing that was written on 2/21 and filed 2/22/23. She also filed the answer to motion for relocation, and then she also sent this one, which was a duplicate, and it was filed a week later. We saw the order directing transport, and we saw the motion for temporary relocation. Now, they already had a motion for a hearing on 4/13 up here. You're going to see that there's a new motion, order setting hearing for 3/29 and a new order directing Sarah to court. And then we're going to look at this letter from Sarah written on the 8th of March, and then the court hearing and court minutes on the temporary relocation. Sarah's going to file another change of address for some reason. And then they cancel that hearing on the 13th. So we will look at all of that next. All right, this was filed on 3/8/23, and it's a second order setting a hearing for March 29th at 2:30 p.m. And this is just a temporary relocation motion hearing. It was filed 3/6, it says. and it reserved 1 hour. And it just has the certificate of service to Sarah. So this was filed on the 8th. She hasn't received this yet at the time she writes the next letter we're going to look at. Then on the same day, filed 3/8/23, they have another order directing Orange County to transport her to the courthouse on Wednesday, March 29th at 2:30. So she'll have another long, arduous day. And then filed at the end of the month, 3/31/23, they have a notice of cancellation for the April 13th hearing. It was canceled by the court and they mailed that out on the 31st because they rescheduled it earlier in the month of March. Okay, and Sarah wrote this on March 8th, 2023, and it was filed March 20th, 2023. Judge Dean, hello again. Per my attempted conversation today to ask former husband FH when he was going to schedule our son's dental appointment, and this is what she really asked about, and when will he really be ordering the small food package I've now been waiting over for 10 weeks and counting. Sorry, I've been waiting on for 10 weeks and counting. This was his abrupt, comical ? Demanding response. I need to find someone to get my stuff and junk out of the garage and put in storage somewhere. However, they're finally leaving. When trying to process what he just dropped on me and talk to him about it, I was told it's not his problem. I said I'm in jail, as he likes to remind me of daily. It's not that easy, especially when I have no one, money, or resources, which he knows. He said while laughing, I know, still not his problem. And he's right, and it's also not the judge's problem to arrange, like, what happens to your stuff. Anything left behind will be put in a garage sale or donated. These belongings are some of the heirlooms from my deceased family, the only things I have of them to remember. Also baby books, antiques, etc., all of my important, meaningful, historical belongings. And where are you going to keep them? Oh, that's right. She's soon getting out, right? They are still leaving no matter what. It makes no difference what I say or do. I told him about the hearing scheduled on 4/13 and he laughed, saying it's not going to happen. How can I be there when my trial starts on 4/10? I keep explaining to him, in all caps, just because there is a date does not mean it's going to happen then. Now, this is very insightful. Of all people I would know if and when going to trial, of all people I would tell him first. Nonetheless, he will be part of my case and will receive information when and if the time comes so he can plan for participation. Because you called him instead of 911 and he's a witness. Clearly, he has not thought about this and his commuting for however long it may be, and if. Also, what happens if there is a change of venue? Where will that be? All-seeing psychic Brian. How does this all end? What? Why would they have a change of venue? It's Orange County prosecutors and Orange County courthouse. So where would they change the venue to if not within Orange County? And what do you mean all-seeing psychic? He's just saying, I don't think it'll be a problem for him to drive there. It's only an hour away or 50 miles or whatever. I'm incredibly frustrated with his continued ignorance in trying to tell me what's happening when, where, regarding anything for my case. Yes, because you're definitely a narcissist and you do not like being told what is happening or having any parameters or anything outside of your control. I am incredibly frustrated with FH continuously accusing me of keeping them hostage and putting off again. He knows nothing but what he sees in his crystal ball and on the internet. Yes, the facts that are posted on your court docket and that his attorney is telling him. Stop being an all-assuming, self-righteous, bullying soothsayer, in all caps. I never owe him any specific details about anything about my case. Pause. And yet, he owes you all kinds of specific details about your stupid storage unit and your car that he's having to pay to store and maintain. He owes you all these details. but you don't owe him any details. Double standard. But will, of course, let him know when I actually am going to trial, if I even am. What is she thinking right now? Because you know she's not taking the plea deal. So what does she mean, if I even am? So delusional. I cannot do any more than I already am and cannot tell the future. No one can, except that you are trying to say it's not happening when everyone around you can see that it is. He may not care about the rest of my life, clearly. I most definitely do, and am quite sure my son does also. My name is still on the mortgage. See prior summons I was served, and another undeniable concern of mine I am trying to address. Does FH have to have my signature to sell since my name is still on all the paperwork? Or does he actually have to remove, as I've been asking for about, I don't know how many years, and was also written in our dissolution of marriage? It cut off the number. In just the last 2 weeks, our son started counseling. Both he and former husband are completely nonchalant about it and seem to not even care about the name of the counselor, duration, or any other information concerning. Why is everything I'm going through all of a sudden so affecting to him or former husband? Are you freaking kidding me? Why is everything I am going through all of a sudden so affecting to him being her son or former husband? The fact that you wrote that in this letter to family court, I mean, so you don't think he needs to go to counseling to deal with his grief and trauma? Like, what kids have to go through this? It's probably not like a common issue for most children to say, hey, my mom took someone's life. It's probably more rare. I have no, that baffles me. Okay. We're going to be talking about that in the comments for sure. Also, the last letter I received regarding my case was from England. And the judge is going to bring this up later, you guys. Moving 3 hours away over 120 miles isn't going to solve the problem. So you're admitting it's a problem. Has former husband thought of the effect it will have on our son moving in the middle of the school year? No friends, new, possibly even worse pressures, culture shock altogether. He's still in the state of Florida. How much of a culture shock can it be? How can former husband tell if this supposed miraculous move really is in our son's best interest? Probably the same way you can tell that it's not. It's called an opinion, and at least he's basing his opinions off of facts, especially if temporary per their petition to relocate. So if granted they're moving back or again or somewhere else when my case is finalized, however and whenever that will be, probably not. That's why it's temporary pending the result of your trial, which we all know how that turned out. And they are now granted the permanent, which is what they were anticipating. If former husband doesn't care about our son getting good grades or even wearing shoes, what? Why is any of this concerning all of a sudden? Maybe he had a dip in grades because of all the stuff he was dealing with. Maybe he doesn't care if he wears shoes outside to play, but I'm sure he wears them to school or something would be said. It's been 3 years. Their petition also states our son is experiencing significant difficulties at school. He is an AB student. Wait a minute. You just said he wasn't concerned about his grades. His favorite class is musical theater. He has 7 friends, sleepovers, a girlfriend, and plays online games with the guys almost every day. What does that have to do with anything? This school is a significant problem in itself. See reviews and write-ups. I thought you couldn't get on the internet, so how do you know that? Not only for our son, but every child who attends there. Oh, so now we should just shut the whole school down because some incarcerated lady that thinks she didn't do anything wrong read a review online? If anything, he can be rezoned to another school and still have the same expected capabilities, opportunities, and be closer to me. They don't want to be close to you. And in the request, they specifically said they need to be out of the jurisdiction of your case. so people can't connect him to it. I'm sure also there are plenty of other acceptable schools within the authorized 50-mile radius. Has former husband even looked into or contacted the supposed far greater educational opportunities stated in the petition? There are such opportunities closer, maybe even better. Has former husband rubbed his crystal ball to see? Why am I never included in anything regarding our son? Another undeniable complaint and concern of mine. I see this as yet another secret delight to former husband in making his heartbreaking attempted move impossible for me, especially if he sells my car, and a bigger disconnect with my son. Nonetheless, per the petition, I will be responsible for all my own transportation costs. Yeah, that's assuming you're getting out, which you're not. But it's an hour or two. You can't buy a tank of gas. Rezone schools. I want to see my son. So she's outlining here what you have to do instead of what you propose to the court. Just rezone to another school. Just fill out the paperwork and get the board to approve you to rezone schools. Okay. I want to see my son on the video chat and on the phone, which I can do from wherever you are. The move is all about former husband. No, it's him making a decision about your son, which is what's best for your son. And you are putting in writing that you don't care about that. You only care about how it affects you. Former husband admitted to me his parents are selling one of their 4 homes and moving to South Carolina. He wants to be close to them, and this is closer than Orlando. Please remember, all the primary reason former husband wants to move and has blatantly laughed at me about repeatedly is because it's more convenient for him since where they're moving is down the street from the prison. So disgusting. This is very hurtful. Brazen, self-proclaiming assumption is said regularly to me and has been already sent in my previous undeniable concerns. Well, a lot of things are undeniable to you. More than once. How ugly and wrong. Also, Judge Dean, if I may, are you aware of the prison stipulations in their petition, page 2, bottom fine print? What page are you referring to? Have you reviewed the long distance parenting plan included also? Oh, she's talking about that footnote. Does former husband really expect me to drive if he doesn't sell my car? Reminded of regularly also. Uber, bus, helicopter, walk back and forth to between Friday and Sunday evening, and I only get to see my son every other weekend. I do not at all agree to this or anything trying to be forced and threatened in order for me to have a relationship with my son. I will no matter what, and former husband will never take that away. It's not his to take, and he does not realize this is all predicted by him in his surety. Everything will fall into place perfectly as he sees, ? This is all unpredicted. How can any of this be proposed on predictions? How is any of this even fair? Why has nothing been discussed? Only him making demands. Absolutely undeniably ludicrous and wrong. Well, that's why they're scheduled a hearing. I don't think he expects you to take a helicopter, but how much time would it really be? So between Friday and Sunday, that's for at least 48 hours. So 4 of those hours, let's say you take the max driving there and back, and he doesn't share any of the travel and doesn't meet you halfway. If he makes you go all the way there and drive all the way back, both ways, let's say if that was the case and you had to drive 2 hours there and 2 hours back, so you would be in the car for 4 hours, 2 of them being with your son. That 2 hours can be quality time. Have you thought about listening to music you both like, or a podcast, or having a conversation? That's a great time to bond with your kid when you're in the car. So it's not taking time away. You're still with your child during the travel. And 4 hours out of 48 is less than 10% of your weekend. So calm down. Most people travel to visit their kids if they don't live together. That's a normal experience for most people. Former husband is using our son as a ploy. So here's her projecting because she's using the son as a ploy. And I feel is selfishly seeking his own gratification and pleasure. As said before by former husband, he can't wait for me to be found guilty and leave. He's not even waiting for that. If that even happens, please tell me when exactly everything predicted is going to happen. Anything when. Former husband knows nothing. One thing he does know is that all my concerns are without, in every way, undeniable and all true. He will never admit and just keeps making his retaliations worse because none of my concerns are made up or false, only experienced or still experiencing, and also that I make his cruel comments, laughter, and actions known to everyone because I'm a tattletale. He is not who he appears nor will ever be. Well, who you're making yourself appear to be is unstable. And a family court is not going to put a child in your care because you're incarcerated. Just like just like the hearing when she was requesting to be uncuffed and the deputy was saying that she had the felony charge and she was trying to say, but I was never convicted, but she kept saying I was never charged with it. And he was like, well, you were charged, but the charges were dropped, but that doesn't mean it didn't happen. And she couldn't wrap her brain around that. This is like that.
So the domestic violence, the original, was dropped. I was never charged with that.
Object is the relevance, Your Honor.
Overruled. You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate, so they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition of probably did not cooperate? Was it a fact or you're just guessing?
It said,
Your Honor, I'm going to object to the question.
Objection sustained.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor, I'm going to object this to the form of the question. It's not a question, it's
Sustained.
Forgive me because I don't know what I'm doing.
Judge Dean, there is so much more to be said. Oh, please don't. On top of my already very legitimate concerns I have already sent in hopes to be remedied, nothing has changed, only gotten meaner and worse. Former husband's egotistical, backhanded schemes, assumptions, and plots are unfair and not at all funny. Who does he think he is now that I'm incarcerated? This shows and explains what kind of person he and his family really are therein, also explaining many reasons contributing to where I am now. There's way more to it all. Two sides. Oh, we see the sides. With that being said, Your Honor, I received a copy of a motion to relocate again today, shorter revised, no prison stipulations or holiday schedule, stating I am only receiving because your J.A. Coffee told his attorney when trying to submit without my knowledge, as usual, throwing shade at the court, I must be included. Otherwise, I would not have this like I do not anything else filed from anyone. According to the clerk's website, multiple documents have been filed, which I have not been included on to receive copies. This is a huge complaint and concern in our last status hearing back in September 2022. Why am I not getting copies? The only documents I have are the original summons served on me in front of everyone. Oh, this is why she's big mad. She got embarrassed in prison. And a now obsolete order setting a hearing for 4/13/23. That's because they rescheduled it and you haven't gotten it yet because they have to mail it. Do you know how mail works? Have you ever mailed anything or received any mail prior to your incarceration? It's not instant. That isn't going to happen apparently because of all the other orders, motions answered, filed, I know nothing about and can't read or open online and haven't been sent copies. How am I supposed to prepare or respond accordingly and timely when I'm not included or part of anything other than being told what to do, how and when, and the terrible ridiculous, she can't spell it, person, parent, I am by former husband. Unfair in every way and wrong. Unjust. Well, again, it's not anyone else's problem how you obtain documents other than what they've mailed you. You just haven't received it yet. And not to mention, when you're in jail, they have to process it and make sure there's nothing wacky or weird in it. So it's going to take you even longer to get it. Because of your incarceration, that is a result of your own actions. Say it with me. I do not know when the new order setting hearing is to happen that was just filed, or the order filed after on the same day. Well, if you know it was filed, that means someone opened it and told you about it and they didn't tell you the date. Since my original letter to you, dated 1/23/23, uploaded 1/31/23, 11 other documents have been filed, uploaded, none of which I can view. I only know what I've received: summons, petition. Why am I still not receiving copies? As said before to you, Your Honor, in the court, this is the only way I am able to be kept updated. I have no reliable, consistent outside resources to do anything or really provide information. I rely on the court for this inclusion. Now, it may be that she hasn't received the copies, but this could also be, this is just me speculating, I don't know, but this could also be a stall tactic for her, because she thinks if she claims she wasn't notified, can they really prove that the mail didn't, like, she didn't receive it or it didn't get lost? I mean, unless they're paying for the mail tracking or like the receipt signature, I mean, she can just claim she didn't get it and delay. So I think this could be a stall tactic of hers, that she thinks she's smart and nobody's going to notice. Please send me copies of everything being filed so I can read and review also. I don't even get a copy of any of my letters anymore, which you wrote them, which notifies me the judge court has received, as I have once before. Why not still? Choppy little paragraph. Because please include me, the respondent, on everything I am able to be. She is in all caps directing this at the judge, yelling. This is my case also, and I am supposed to be treated equally, fairly, and properly as any party to a case should be, with or without an attorney. This is my life. This is my life with my son. There is nothing more important. Yeah, the judge doesn't have tons of cases on his docket. You're the most important. Just you. I am not helpless nor giving up in any way in anything, especially regarding my son and our life together. Futuristically, FH needs to destroy the crystal ball and don't quit his day job when he has one. That is some shade you have no business throwing. When was the last time you had one? Because when you filed in 2018, you were unemployed, receiving unemployment. Remember that? I'm sure undeniably by having one also and not relying on his parents' millions. So what if he is? His economic circumstances would most definitely improve in so many ways. You know, it would be great. I mean, that would be one thing going on in his favor, that his family has money, so he has the time to take some time from work and focus on your child, since he is now the sole responsible parent. You should be happy that he can do that. I am me and am trying relentlessly forever. Oh my God, this is one word that does describe her. Relentless. I believe in myself and am confident in God. I will get through this. We all will. This is not forever either. This is forever. This is not forever either. My circumstances or remaining life. Your life is not forever. No one's life is forever. Stop trying to make it. I am hoping former husband can understand and cooperate as unobtrusive and cordial as possible in order for everyone's life to be successful and happy. This includes me also. Yeah, and that's all you're thinking about. He's thinking about your son. Please send copies so I know when the new hearing is scheduled, so I can plan accordingly. Please understand too, we inmates are woken up at, is this 3 or 8? I think 3 a.m. Sit in 3 to 4 holding cells for 10 to 14 hours when going to court for 30 minutes of your time. Yeah, and again, not his fault. You are an inmate because of your actions, so this is a process you have to follow. for everyone's security in the courtroom. They have a processing procedure. Is it comfortable? No. You know what else wasn't comfortable? That suitcase. So when you're sitting in a cell for 10 to 14 hours, you need to think about George. And this is you begging the judge to be let out, and you just think about George. Pardon me. So it's also a physical preparation on top of the mental. I very much would like to be ready. Please. Thank you for your time, patience, understanding, and copies, Sarah Boone. And then these are the court minutes from the hearing held on the 29th of March in no location. And it says that Brian and Sarah and Joshua Martell were present. The hearing was held in person. The respondent was transported from the Orange County Jail, which she previously complained about in this letter, that it takes 10 to 14 hours so she can have 30 minutes of the judge's time. But she still requested to be transported from Lowell in Ocala all the way to Orange County. So how much longer would that take? And the ruling was the petitioner's motion for a temporary relocation was granted legally by the court. So all this ranting and raving she's been doing, this was legally granted. Mr. Martell was to prepare the order. They had case management scheduled for 4/13/23, which was canceled. So she would have found out about that on the 29th in court. And the respondent can reschedule hearing if needed. Court recessed at 3:40, subject to call, filed in open court. What time did it start? Did it say? Oh, 2:28. So from 2:28 to 3:40. So they had a little over an hour hearing, 10 hour and 10 minutes. And here's that order the judge wrote. It was filed on 4/5/2023. Order on motion for temporary relocation filed on March 6th. This cause having come before the court on March 30th. I thought it was the 29th, but either way. On the petitioner Brian C. Boone's motion for temporary relocation filed March 6, 2023, and having reviewed the file, heard the testimony of the parties, listened to argument from counsel and the respondent, and being advised in the premises makes these findings of fact. A, this court has jurisdiction of the subject matter and the parties. B, there is one child born in 2010. C, there has been a substantial change in circumstances since the entry of the original final judgment, which she continuously referred to in this latest hearing over and over and over and over and over. But he's violating the 2018 order. It's an active order. He's violating the order, which the judge did put her in her place and say, yes, you too are violating that order. She said, would you say that you've held up your end of that order? Which I love that she said that. But that's the whole reason they were even in court to do this modification, because there was a substantial change in circumstances. She doesn't seem to be able to understand that. If being incarcerated for life is not a substantial change in circumstances, I don't know what you would qualify as one. D, the petition to relocate filed on February 14th, 2023 was filed properly and meets all the statutory requirements. Relocation factors. After evaluation of the statutory factors, the court finds it is in the best interest of the child to grant the temporary relocation, and from an examination of the evidence presented at the preliminary hearing, there is a likelihood that upon final hearing, the court will approve the relocation of the child. Specifically, the court finds as follows. A, and it says the nature, extent of involvement, duration of the child's relationship with the parent or other person proposing to relocate with the child and with the non-relocating parent and others in the child's life. And then it says the mother is currently incarcerated and has not been in the physical presence of her son for over 3 years. The mother is currently involved in a high publicity criminal case, and the child has suffered at school as a result of everyone knowing about his mother's case. The father is currently single and does everything for the child. This is listed in the court minutes. Additionally, the father's sister and nephew, the child's cousin, live there where they desire to relocate. The child would have the opportunity to go to school with his cousin upon relocating. The mother does not have any family in the Orlando area. B, age and development stage of the child, needs of the child, and likely impact the relocation will have on the child's emotional, educational development, etc. There has been bullying at school due to some of the videos regarding the mother going viral. The mother admits, she wrote this in her letter, that she gets letters from England and China due to the popularity of her case. So she's just reinforcing the widespread publicity aspect of his argument. By relocating, the father is confident that no one will know the situation and the child can get a fresh start, or at least no one will know he's tied to the mother, in the new place. They might have seen the video, but they don't know he's her son, like people did at his other school, because she mentioned like going on chaperoning a field trip, like people saw her face there. C, the feasibility of preserving the relationship between the non-relocating parent or other person and the child through substitute arrangements that take into consideration the logistics of contact, access, and time sharing, as well as financial circumstances of the parties, whether these factors are sufficient to foster a continuing meaningful relationship between the child and the non-relocating parent or other person, and likelihood of compliance. The substitute arrangements, once he or she is out of jurisdiction of the court, nothing will change due to the relocation because the mother is incarcerated and they can only communicate by phone, which the child can do from the new location. D, the child's preference. They did not present evidence of what the child preferred at this hearing. E, whether the relocation will enhance the general quality of life for both the parent or other person seeking the relocation of the child, including but not limited to financial, emotional, or educational opportunities. It says the father is a programmer, generally works from home, and can do his job from there. The father believes that moving away from the area would provide a fresh start to him and his son, and they could leave behind bad memories. F, the reason each parent and other person is seeking or opposing the relocation. See other factors. This I love right here. The mother didn't have an articulable reason as to why she opposed relocation. Now, the hearing was for an hour, and she more than likely rambled on all of her same old regurgitated, tired, old, reused arguments, but she didn't have an articulable reason. That's what she needs to focus in on. None of it was articulate. G, current employment, economic factors. It just says see other factors. It doesn't list anything there. H, the relocation is sought in good faith, and the extent to which the objecting parent has fulfilled his or her financial obligations to the parent or other person seeking relocation, including child support, spousal support, and marital property and marital debt obligations. The mother states the father isn't paying alimony as ordered by the court, so they did put that in the minutes. Career and opportunities, it just says see other factors. No evidence was presented about substance abuse or DV. Demonstrated capacity and disposition of each parent to provide a consistent routine for the child, such as discipline, homework, meals, bedtime. The only parent capable of creating a routine at this time, it says, is the mother. But I think that was supposed to be the father. This is like a big mistake here. Any other factor affecting the best interest of the child is set forth, and no other factors were as considered, so it is ordered and adjudged. The court has jurisdiction. The petitioner's motion for temporary relocation is granted, and the petitioner is permitted to relocate pending a final determination of his petition to relocate. So he's allowed to move there pending the final determination, which they just had. 3, the court orders that the respondent continue the same contact she has had with the child during her ongoing incarceration, and that the petitioner will cooperate in facilitating this contact. So that is part of the court order as well. So when people say Brian is enabling, Brian is this and that, he is court ordered to facilitate the contact right here. The court expressly retains jurisdiction of this cause for the purposes of enforcing, construing, interpreting, and modifying the terms of this order done and ordered, and it was sent to the attorney and Sarah Boone. All right, and that was the order filed 4/5/2023. So that order was mailed out, and Sarah, 2 days later, is going to write this motion for contempt, and then they're going to have an order setting a virtual hearing, a motion to continue the contempt hearing, an order on the motion, and then more letters from Sarah. And then in May, Frank Bankowitz will enter notice of appearance. And then there was a delinquency. And then we get a really juicy letter from Sarah on August 1st. Another notice of delinquency, some return mail. By September, Frank is going to withdraw. And there's a hearing and an order to transport her for the hearing. They cancel a hearing that was originally scheduled, and then Sarah writes another letter. Well, it's filed anyway. She had written it. So we have quite a bit to go through 2023. We then have another notice of a hearing, some orders, and then in November, finally, Frank was granted his withdrawal. And then we just have 2 things in 2024. So I'll probably throw those in, depending on how long the Sarah letters are, with the second half of 2023 video. So we're going to end here for now, because this video is almost an hour and a half. And then I'll do the second part of 2023, hopefully all in one video, depending on these letters from Sarah. And then I'll see if I can't throw these 2 2024 things in, and then we'll be in 2025, and we'll kind of go over all of that. And at the end of all of that, I'll kind of like do a recap of the latest hearing, and hopefully we'll have some more documents from the court docket as far as Sarah's closing argument. That's all I have for you today. And I just wanted to thank you all so much for watching. I'm having a great time making this content, and I'm so glad that you're having a great time watching it. So thank you so much, and I will be in the chat.